financial crisis recovery.
Foreclosure, short sales, bankruptcy, credit card debt, job loss, depreciating home values, money management. Peace of mind when it comes to your finances seems completely out of reach under current conditions, but there is a way to achieve it. For the next 60 minutes, you're going to find out how to cover your assets. Cover your assets.
They're looking to liquidate assets, which means they take them from you. And so
liquidate assets from consumers.
From consumers who don't have a lot of assets. So it's really kind of a crying shame. But, one of the big parts of the case analysis that I make when you come in is, what do you got for assets and what are we going to do with them? Can we protect them all? And if we can't, are you still willing to file based on the fact that you may lose a little bit of assets? Or can we do some pre-bankruptcy exemption planning to liquidate them basically for your own purposes, for your family's needs and things like that, or shelter them in some other way? Or maybe we need to look at another case.
What are you going to lose and what are you going to keep, basically?
Yeah, and
right?
honestly, and most people don't know this, and I get this all the time, and I'm always kind of shocked, but I'm in it every day. But I just had a guy the other day doing a consult, and I'm going through his assets. Well, I'm not going to list my guns. And I said, well, first of all, not listing something is fraud, and you better get a new attorney if that's how you want to approach this. But let's talk about this. Well, the guy had what's called a wild card exemption, almost $12,000. That's how he's going to protect those guns and then some. So he wouldn't lose anything. The reality of it is, most people don't lose anything. Some people could. Some people do. But it's really important to take a look at that. And so I was just in the hearings last week. There's this relatively new attorney. He's threw out a web page. That's the big leveler these days. I'm experienced. I'm on the internet. I'm cheap. And so he had like 4 hearings, I think. Man, his paperwork was screwed up. And that's one of the differences between good attorneys and bad attorneys. It's preparing the documents correctly and applying the law correctly. 90% of, take a home project, for instance, is getting the ground ready, making sure your materials are there, making sure you're ready, making sure you got the time to do it. Did the analysis first, because the actual work of it isn't usually that tough. Same thing in a bankruptcy. Document preparation, being thorough, that's really the key. And most of my clients, just the same day, my case finally gets called. The calendar was all backed up because this young attorney messed up paperwork. It took forever for the trustee to work through it. They called my case, bada bing, bada boom. We're done in like 3 minutes. And my client looks at me and says, wow, that's it? I said, yeah, that's it. That's what you paid for. Less stress, streamline through the process, because I know what to put in the documents, I know what to keep out, I know how to say things. I know what kind of documents to bring to the hearing, because the trustee may have a question that says, well, what about this? And I'll pull it out of my file and say, here you go. That's what you're looking for right there. Here's this, here's that, here's the other thing. And so that's where the experienced attorney, being able to spot the issues, know how to present it, because in essence, what I'm doing in any client situation, it's like a big jigsaw puzzle. I'm taking their financial life and I'm tearing it apart and I'm putting it back together in a format that works to get you drawing back to your allusion to the trustee, that's your adversary, to get it by the trustee in as smooth a fashion as possible and to get that ultimate discharge in a bankruptcy case.
Well, the other thing I think that is most certainly lost on most people is you brought up the analogy where, I don't want to bring this up in bankruptcy court. And I don't want to disclose it. The thing is here's the thing that's shocking to me, David, is the multitude of inexperienced attorneys who will go along with this. And this is insanity. For those of you listening, you need to understand something. Your attorney is not out there to teach you how to avoid paying creditors, because if they do that, they can lose their own license. And God knows there's a whole lot of attorneys out there who have lawsuits against them because they misrepresented information to their clients.
We do teach people how to not pay their creditors.
Well,
that's one thing.
Yeah.
What we try and avoid is perpetrating a fraud on the bankruptcy court and the bankruptcy system.
Exactly.
That's entirely
Which
different.
is a fine line.
Well, a lie is a lie. Not disclosing assets. It's tougher these days because the internet's a wonderful thing. Trustees go on the internet and check with the Department of Motor Vehicles. There's all kinds of land registration sites out there and things like that. I mean, if you got real estate out there, you didn't disclose it. Bad problem. First, there's fraud, and Denny Hecker's probably looking for a new cellmate somewhere. I don't know where he's at these days, but he's in prison for bankruptcy fraud. The judge's sentence says you're a scoundrel because he obviously lied. He didn't think the rules applied to him. I'll tell you, folks, you come to me, and if I get one whiff of somebody that I think is withholding information or wants to go through a bankruptcy case without disclosing everything, I'd say, I'm done. It's not worth it for me at all.
Yeah.
And the consequences, not just for me, I mean, it is for me because I'm worried about that for my own practice, but for my clients especially, you don't want to go to federal prison for bankruptcy fraud. And one of the things that people don't know, well, let's say you do get caught for something, get referred to the United States Attorney's Office. That's who comes after you. I mean, these are heavy hitters, obviously, right? And they'll throw you in jail. They will revoke your bankruptcy discharge, which means you don't get rid of any of the debt. And guess what? Any assets that you had, the trustee still gets to liquidate them.
Right.
So you're never ahead. If you want to take advantage of the bankruptcy system, play by the rules is the way to go.
And the last person in the world, this is my point, that you should go to hide and not disclose assets. The last person in the world you would ever want to talk to about how to not disclose assets is a bankruptcy attorney, because if they're a good one, they're going to say, I don't want any part of your case if you're trying to do that.
Yeah, well, exactly. And there are some people, you can tell they've been to attorney, and then you'll see that they've visited you, and you'll say they filed the case, and you're just thinking, I know that person didn't disclose this stuff. Of course, confidentiality applies. I can't tell anybody, but I'm sitting there thinking, I hope they get caught.
Yeah, and I'm not, and I don't want to represent them any longer. And you know what?
Well, that wouldn't be my client. It would be somebody else's client then, but because I'm not going to represent them, So yeah.
Well, let's also talk, before we take our next break, let's also talk about where things can take a right-hand turn because information was not presented properly, and then talk about, David, how when there's a case that is brought against you because of some of these things, and now your bankruptcy attorney doesn't represent you because you take it to the next level and it becomes a whole different issue potentially. Talk a little bit about that.
Where it can take a wrong turn. Well, of course, my cases never do, but I can tell you where I've seen them. Somebody sitting up in front of the trustee. The trustee is eliciting testimony, looking at documents, and I say, this bank's it's kind of interesting here. What's this big withdrawal here? What's that all about? And it turns out, they paid off mom or dad or something like that. Or, they're looking at their documentation. Maybe they're looking at a divorce decree if you've been divorced recently. Well, what happened to that RV that you were awarded? Well, it turns out I transferred it to my daughter, and it was worth $30,000, and she paid me $3,000 for it, or something like that. Because then the trustee is, of course, interested in assets. But worse than that, now all of a sudden you failed to disclose something important. There's a fraud on the bankruptcy court. Whether or not it reaches the level of criminal fraudulent intent that they can prove, or it was just an honest omission or mistake, that's debatable. But you don't want to get into that spot whatsoever. That's just a big problem.
So really, the point is that the last place in the world you want to uncover things.
You don't want to do it at the hearing. Yeah.
In the hearing. A proper analysis should uncover that, and in that way, your attorney is prepared to deal with that in court. You've already made allowances for it. But to have something like that come up because the analysis or the petition was not looking at everything, wow, what a terrible situation that could be.
This is why we block like an hour and a half to 2 hours for our consults, because we're very thorough. We cross the T's, we dot the I's. There should be absolutely no surprises at the hearing. There's nothing worse than that. And, for clients, too, because they really don't know what's going on or what's going to happen. They're just sitting up there and they're getting grilled, And if all of a sudden a trustee really starts honing in on something, they're like a deer stuck in the headlights. They don't know what's going on. I can't stop the trustee and say, well, blah, blah, blah. They got to go through it, and hopefully they didn't trip all over themselves and bury themselves at that point. And it would have been nice if they would have told me about these issues before the hearing so we could have dealt with those.
Well, this is a point that almost we could spend the next 5 hours on rather than 1 hour. But the thing that I often see, and I've heard this from many attorneys. Look, I've heard this from bankruptcy attorneys. I do not get paid for a particular outcome. I get paid to file the case. So when you go to an attorney and your perception of bankruptcy is a Chapter 7, even if you don't necessarily know how to verbalize that, in your mind, bankruptcy means the discharge of debt and you're able to move on with your life in a reasonably short period of time, not paying or owing anybody any money when it's over. We need to understand the contrast between the two personal bankruptcies that are generally used, Chapter 7 and Chapter 13. Chapter 7 is a discharge of debt. Chapter 13 is a repayment plan of generally 5 years. Well, if your attorney doesn't do a thorough analysis and you tell them you want a Chapter 7, but they're saying, hey, look, man, I don't get paid for an outcome. I get paid to file your case. So if in the middle of the hearing, the trustee says, look, we're throwing out a Chapter 7. This is not happening. You're a Chapter 13, and your attorney says, well, your next best option is a Chapter 13. That's just the way it goes. To you don't think that's a big issue, but in fact, you just went from the discharge of debt to a 5-year repayment plan, and to the attorney, they're getting paid to file the case, not for a particular outcome. Wow, do you need to know a little bit about this? So when we come back from the break, we're going to talk about that with experienced bankruptcy attorney David Kingsbury. We're going to talk about how that can go wrong and why it's so important to understand the distinction and make sure that you have a thorough analysis with your bankruptcy attorney and you know clearly going in if you're a Chapter 7 or a Chapter 13, or if it is Chapter 7, if there's a chance that it may wind up in a Chapter 13 and you understand the implications of that. So with that, we'll take our next break, and on the other side of the break, we're going to be talking with David Kingsbury. By all means, go to our website, CYA21, and download the Financial Crisis Bible to glean more information. It's a free download for you. Anybody you know who is facing a financial challenge, wants to ensure that they never are, by all means, go to www.cya21.com and download the Financial Crisis Bible. We'll be right back. We're back with Cover Your Assets, speaking with attorney David Kingsbury, who is the most experienced bankruptcy attorney in Minnesota. I'm going to keep using that.
In the universe. Just kidding.
We left the last segment talking about, that for the whole, a lot of attorneys look at bankruptcy not necessarily as guaranteeing an outcome. And frankly, no attorney really can, because there's always things that are beyond their control and things that might not have been disclosed. But an attorney is oftentimes going to say, look, I get paid to file the bankruptcy. I don't get paid for a particular outcome. So as David said, a lot of times they don't really even look at the file. And they've got, they're putting the petition together. They throw it all together. And then in court, something comes up and it goes in the other direction, which is a Chapter 13. And, hey, oh, well, that's the way it goes. And for you, it can be a catastrophe. How would an experienced bankruptcy attorney like you, David, avoid that problem happening?
Well, those kind of situations for my practice are very few and far between. I'm not going to say it's never happened. When it has happened, it's when my clients fail to disclose something important to me. Either it's not necessarily the panel trustee that's actually doing your hearing your case. There's some forensic bean counters at the United States Trustee's office who review every case that comes in, and if something just looks a little bit off for some reason, they're going to ask for a lot more documentation. These are usually the higher income debtors. Again, and not everybody that does bankruptcy is broke. Most people that do bankruptcy aren't broke, so there's a lot of people that have money. And so the ones that are higher income debtors, they're going to scrutinize their paperwork more, and they're going to look for documentation. If they see something that just doesn't really look right, then they're going to glom onto that. And they're very good investigators over there. And if they turn something up, they can't force somebody into a Chapter 13. They can say, guess what? We're going to bring a motion to object to your Chapter 7 filing because what you got going on here, we think it's kind of abusive. And they don't win every time they do that, but sometimes they have, they've uncovered